The jury had 3 questions for the judge just moments ago, and before those questions were read, Karen Reed's defense team went over to her family, and whatever they said, her family seemed very happy by what they were told. Now take a look. This is Karen Reed walking into court this morning with her attorneys. The 3 questions that were asked by the jury moments ago were, what time is the time frame for the OUI charge, 12:45 a.m. or 5 a.m.? The jury also asked if the video clips of Reed are actual evidence. Meanwhile, the group of 12 also asked, does convicting a guilty on a subcharge convict the overall charge? The example they gave referred to a lesser included drunk driving charge.
Very rare to a hospital, and it ends up being a legal case. It's not common, I think uncommon.
You'd agree that there are differences between screening tests that are conducted at hospitals and forensic tests that are conducted by law enforcement, right?
Yes.
And doctor, what was the result of the testing for alcohol in the defendant's blood when it was taken shortly after 9 a.m. on January 29th?
93 milligrams per deciliter.
Good afternoon, Dr. Fowler.
Oh, good afternoon.
The Good Samaritan lab is a clinical lab, not a forensic lab. Is that right?
Correct.
And hospitals are not in the legal business of calculating an individual's blood alcohol concentration. Is that right?
99.9% of the time, we are not in the legal business. We are testing alcohol for the diagnosis of alcohol intoxication. But occasionally, a case may come, very rare, to a hospital, and it ends up being a legal case. It's not common, I think uncommon.
You'd agree that there are differences between screening tests that are conducted at hospitals and forensic tests that are conducted by law enforcement, right?
Yes.
You testified earlier today that your lab is accredited by CAP, which is the College of American Pathologists. Do you recall that testimony?
Yes, I do.
But CAP is a clinical laboratory accreditation, not a forensic accreditation, right?
We don't have the forensic accreditation for Good Samaritan. We've never had the forensic accreditation.
You've never been accredited by a forensic accreditation team, right?
No.
Whereas in a forensic setting, tests for blood alcohol concentration are designed to produce results that are reliable and credible for use in court. Correct?
Correct.
The lab at Good Samaritan has never been accredited by the ANSI, which is the National Accreditation Board known as ANAB. Are you familiar with that organization?
No.
Are you aware that ANAB is the forensic accreditation body that in the United States that ensures that laboratories' procedures meet the minimum standards necessary to ensure results are reliable and credible for use in court?
Objection.
Sustained.
Now, the most reliable method of forensic ethanol testing is called headspace gas chromatography, or HSGC. Are you familiar with that process?
Yes.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders.
Those medical records pertain to a Miss Karen Reed from the Good Samaritan Medical Center. Is that correct?
Yes, they do.
Okay. And in those records on that 52nd page, what was reported as the defendant's ethanol level?
The results are recorded as an alcohol result with a value of 93 milligrams per deciliter.
And pursuant to those records, at what time was that sample taken from the defendant at the Good Samaritan Medical Center?
The collection time listed on the medical records is January 29th, 2022 at 9:08 a.m.
Now, that recording and a measurement of milligrams per deciliter, is that typical for how you see ethanol measured by hospital labs?
Yes.
And did you conduct the serum conversion for this defendant's reading consistently with how you do in every case that's assigned to you?
Yes.
Now, please explain to the jury how you're able to convert that serum level reading to a blood alcohol concentration.
So the way that the calculation is performed is kind of in two steps. So the results are listed in milligrams per deciliter, which is common in clinical testing. And to convert it to the type of units that are typically used for blood alcohol concentrations, we just divide by 1,000 to get that into the right units. So 93 milligrams per deciliter converts to 0.093 grams per cent. We apply two conversion factors, a low and a high conversion factor, to account for the range that we see in the typical population. I'd mentioned earlier that serum is usually between 13 to 19% higher, so we divide that 0.093 by 1.13 and by 1.19 to get a low and a high blood alcohol concentration for that range. What we're doing with this calculation is taking what we know about how quickly the human body is capable of breaking down alcohol and applying that rate of elimination to the time interval between when the sample was collected and tested and when there might be a particular time of interest. When we're looking at a serum conversion and then being combined with a retrograde, we take the smaller of the serum conversion range and we add that to the slowest elimination rate multiplied by a time interval. And then we also take the larger of the serum conversion values, and then we add that to the fastest elimination rate multiplied by the time interval.
Now, what categories of information do you need in order to perform a retrograde analysis?
We need to know what the blood alcohol concentration was at the time that the sample was collected. We need to know the time the sample was collected, and we need to know the incident time or the time of interest that we're sort of calculating back to. There's a couple of requirements to be able to perform this calculation that we have to ensure. We have to make sure that there's at least been 2 hours in that time interval between the time of collection and the time of interest that we're looking at. We can't calculate backwards with that very narrow window because we can't be sure that the person is entirely in the elimination phase, that their body has reached a maximum blood alcohol concentration and they're just breaking down alcohol at that point. The time of incident is important because that's what we're basing the math on.
A forensic lab exists for a different purpose than a hospital lab, is that right?
Correct. They have different customers and sort of different scope or intention for the use of their results.
You have no information that the lab at Good Samaritan Hospital is an accredited lab, correct?
Correct.
And in addition, Good Samaritan Hospital is an external party in terms of its relationship to your lab, right?
Yes, and for that reason, the type of calculations that we performed based on medical records from Good Samaritan are outside of the scope of accreditation in the crime laboratory system.
Right. It has no relationship to your crime lab, the Good Samaritan lab, right?
Correct. The same policies and procedures are applied when our laboratory analyzes serum, or if we needed to do a retrograde extrapolation on testing that was performed internally that's covered by the scope of accreditation. But as you're mentioning, the testing was not performed in my laboratory. I don't have any direct knowledge or understanding of their QC procedures, of their accreditation requirements, or their testing procedures at all.
You anticipated my next question. So basically, you cannot personally vouch for the ethanol testing that was performed at Good Samaritan, correct?
That's accurate. The reliability of the results that my calculations were based on, my calculations are only as good as the numbers that I was provided. And like I said, the same math that I did here, I would do to my own internal standard or my own internal testing, anything that I performed testing on in the lab myself. But the results that I started from, I don't have any direct knowledge on their accuracy or reliability.
The second question.
I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is very simply, you give this the weight, if any, that you decide is appropriate.
Are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question.
Appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to the third one. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2, and I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps we could formulate an answer that says something along the lines of, no, new verdict slips have been provided that will make it more clear, or something of that nature. As well as a decision of guilty on the OUI charge 002, number 5, is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law. And then there are suggestions that we have regarding the edits that the court has made to the verdict slip. And I'm happy to go over those with you and put those on the record.
Okay, go ahead.
With regard to going from the top to the bottom, just under number 1, number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the consistent language that it's added throughout the verdict slip. If you, quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear. The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right, I think I'm going to leave it because it appears only under the guilty.
It appears only on?
Under the guilty. So go ahead. I'll hear you further.
Going further, going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent, if you find the defendant guilty of the lesser offense of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them.
Correct.
Which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again.
Hold on one second.
Of course.
Okay.
We had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following. And there's a typo. It says the parenthetical
We fixed
says,
it.
Check one of. Okay.
Yes, so we changed of to or.
So my only suggestion to that would be to, again, add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide. Moving down under sub 5, the
We still
OUI.
need to say stop and sign the verdict slip.
Right. After the word stop and sign the verdict slip.
Yep.
And then under sub 5, again, the same thing. We just suggested that for consistency that it say, if guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be
Yeah.
changed to the defendant.
Sure.
If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan?
I don't have any disagreement with the edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think that the edits, this proposed instruction explains it. Yes.
All right. Would
I don't have any issue with if you state, if you decide on a lesser included offense, it does not include the earlier offense. And I'm not sure of the exact language that can be used. I don't think that's necessary, but that is something I wouldn't have an objection to. But I think the form that you filled it out with the edits is going to be sufficient for them to follow.
what do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense. It would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain, if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
Yeah, I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should re-emphasize that, and we're not asking for it.
All right, so you're waiving it?
We're waiving it.
Okay.
Yes, thank you.
All right, I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can, and we'll make copies. So we'll bring the jurors in. Let them know that we'll be bringing them in shortly, Tony. So for the third question, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, Then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor, and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. We received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not certainly not for it. I agree. We can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than 1 count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer it.
So I don't know if I want to put you in an uncomfortable position, Mr. Yannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, Your Honor?
1 minute.
How about 1 minute? You guys are 10 minutes late.
We just need 1 minute. Thank you.
Just with a very slight tweak with the court's language, I don't have a principled objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question I can answer, for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict, and that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. that would be punishment. Of course you can't answer a question like that. This is not the consequences of the verdict, it's how do they report a verdict. So I think saying, I can't answer this is sending a false message to the jury. If the court would simply indicate, this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns and it protects Ms. Reed's rights. I think that...
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
Add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
I won't allow the court to finish writing, but at this point, that is over our objection.
I understand.
I just want to make sure the record is absolute. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights.
Okay.
This way it does.
Okay, it was a clear question that the defense first told me to ignore. So
I didn't
there's
tell you to
that.
ignore anything, Your Honor.
All right, we are all set. So let's send this in.
Well, there's one question in the Karen Reed retrial leads to speculation on whether it plays in Karen's favor and whether the end is near. Twice came the questions from the jury room, several in the first round, asking for guidance from the bench.
The jury asked 4 questions, and when some of Karen Reed's family learned what the questions were about, they seemed very relieved inside the courtroom.
Let's stay tight. Yep.
Karen Reed was quiet, walking out on day 3 of deliberations without a verdict.
Let's find out if Mr. and Mrs. Reed have any comment. Hi, Mrs. Reed.
Hi.
Mr. Reed, any comment?
Not really. Not really.
How are you spending the deliberation time?
In prayer, and, that's about it.
Mr. Reed, your family looked visibly relieved. There was like an exasperation moment when you found out the question.
Yes.
Do you feel the jury's leaning a certain way?
Well, you make inferences to the best you can, but you never know what anybody's thinking.
Are you prepared for a verdict?
Inside the courtroom.
I'm prepared to hopefully find our daughter free. Yeah.
Would just OUI be a win for your family? If it was just that lowest charge?
I'm not sure.
Okay.
Yeah.
Talk to me about the emotion inside the courtroom.
You can cut it with a knife, I think. Yeah. I've got to run, okay?
Some people were crying when they learned about the instructions or questions.
Were people feeling emotions?
I didn't see any people crying, unless I just didn't observe it.
What were you feeling?
Again, it's difficult to read into, what those questions were. I don't want to make any inferences or intimations from those questions. I mean, we're all reasonable people. You heard it yourself, and I'll just go with what I heard. But I mean, to extend beyond that, we'll play this thing out, come in back in about an hour, and that's how we do it. I mean, I've been playing this out for 3.5 years.
Did you feel the judge was responsive to what the defense said?
I'll let the attorneys respond to that.
Would you consider a conviction?
Why they wanted you back at 1:30?
Mr. do you want to?
Yeah, I've got. No, I'm not sure. I'm not privy to that.
Would you consider an OUI conviction a win for Karen Reed?
I just want our daughter home. Yeah, and free.